anything besides a bullet strike that would lead you to believe a shooting had occurred in the bedroom? Well, there was blood, there was a bullet strike. Was there any other evidence of a shooting in that room? What about casing?
Yes, there was a spent casing next to the bed. It was between the west edge of the bed and the west wall of the bedroom.
All right, do you recall what kind of casing it was?
It was a 7.62 by 39.
All right, and what, in your experience, what kind of weapon would a 7.62 by 39 be come from? A casing that is a 7.62 by 39.
Most commonly, that's encountered with AK-47 or SKS type assault rifles.
Okay. And you know that as it was.
You may have said, was there a casing or multiple?
There was one spent casing
One casing.
on the floor.
And was there other ammunition as well?
Yes.
Was that ammunition related to the, was that ammunition the same kind as the 7.62 by 39 or not?
Now, there was 7.62 by 39 rounds recovered, but that was recovered by Officer Denard.
Okay. And you did not see them?
Well, I saw them, yeah, but they were not in the bedroom at that point.
They were not, okay, they were not in the bedroom. Do you remember where they were?
Officer Denard had that secured. He was by the front entry door.
Do you recall if there was a television that was in the living room as well?
Yes, there was a large screen television.
Do you know if it was working or not?
I do not. I was told it was not, but I did not try to turn it on or turn it off.
Okay. In the bedroom where you were, was that TV on or off when you were there?
In the north side bedroom, there was a TV in the corner. It was turned on, and the volume was turned on.
That's it for Sergeant Bowser.
Thank you, Sergeant Bowser. When you get to the scene, you are not the first officer at the scene.
That's correct.
Other officers were already present.
I was the first homicide personnel at the scene.
Okay, but there were other officers who were already there.
Yes.
What were they doing, if you recall, when you arrived?
Securing the crime scene, knocking on doors for the canvas.
Okay, so there were officers outside, checking to see if there were any people outside who saw or heard anything, right?
Correct.
And were there officers inside?
Yes.
And the officers you saw inside were doing what?
Officer Denard was securing the weapon in the front door. Officer Todd was with the two youngsters in the living room of the location. There was two officers in the back of the house with Mr. Richardson. And he was basically sitting on a stool or a chair in the kitchen area.
Okay, and just so I'm clear, when you arrived, Miss Patricia Johnson was not there, is that correct?
I was told that she was present in a car parked down at the corner of the street.
She was not in the location?
That's correct.
Okay. And so when you arrive, you're with a partner?
Yes.
And who are you with?
Sergeant McGinnis.
Thank you. And so you are directed to a certain location, is that correct?
Correct.
Is it fair to say that at that point EMS had come and gone?
Yes.
All right. So you did not see a body or anybody who was injured in the home?
No.
Okay. So at the time you get there, you proceed to start conducting your work. Is that correct?
Yes.
Are you directed toward any particular location in the home?
Well, our standard protocol is when you arrive at the scene, you talk to the officers that are primary, the secondary, and or the supervisor that's there.
And they give you information?
And they give you a brief rundown of what they saw, what they did, the layout of the scene, and then you do an inspection of the scene.
Sure. So based on the information you received, do you go to a specific location within the home?
Yes.
And where do you go?
It's the north side bedroom.
Okay. And when you get into the bedroom, is there anyone in the bedroom?
No.
Okay. And in this room, you indicated there was a bed.
Yes.
Is there a dresser?
There was two nightstands type things next to the bed. There was a chair, TV stand. I don't recall a dresser being there, like a classic full-size dresser.
Okay. And is there a table of some kind in the room?
Yes,
And you indicated there was a TV.
yes.
Is the TV on that table?
The TV was on a table in it would be the southwest corner.
Okay,
of
is
the
there an
bedroom.
additional table in addition to the one that the TV was on?
There was two nightstands, I guess
Okay.
you could call them tables.
Okay.
To either side of the head of the bed.
Okay. And that's what you recall in terms of of furnishings in the room?
Yes,
Okay. There is a closet in the room.
yes,
Did you go into the closet?
yes.
And in the closet, are there clothes?
There was quite a large amount of clothes,
Okay.
yes.
And just so I'm clear, when I say closet, describe that closet to me if you could. Does it have a door on it?
It has a door on it.
And when you see the door, well, the first time you see the door, is the door open or closed?
It's open.
All right. And do you know how that door got opened or closed before you got there?
I do not.
All right. You don't know if one of the officers who was there before you opened the door to look to see what was in the closet? Maybe as they were doing a search to see if there were any weapons
I can't answer that question,
Okay.
ma'am.
But normal protocol would be for the first officers who arrive at the scene to search for, people who are injured or people who may be hiding.
Absolutely.
Or weapons that are on the scene.
Yes, ma'am.
And it would be normal procedure for them to look in a closet to see if there are weapons. Is that fair?
Yes, but in a limited fashion. It would be more of a protective sweep rather than a search.
Exactly, because the first officer would do what you described as a protective sweep.
Correct.
Okay.
That's what they should be doing, yes.
Sure, okay. So when you get to that room, when you first see that closet, the door is open.
Yes.
All right. And you don't know what search of that closet protective sweep had been done before you got there. Is that fair?
I was told that there was no persons in the closet and no weapons visible in the closet.
Okay. And you took that for your purposes, that a protective sweep had been done.
Yes.
All right. And so do you, in fact, though, search further into the closet?
Once the search warrant was ran and signed, we did a thorough search of the entire premises.
Okay.
I'm sorry, let me retract that. The entire lower flat and the basement area.
Okay. Now, you indicated when you arrived, you saw what you believed to be a bullet hole in the wall,
Yes,
and that you were present when that was measured to be 19 inches from the ground.
Correct.
Is that correct? Now, you also indicated that it appeared perpendicular.
it struck the wall perpendicular to the surface of the wall.
Okay. And just so I'm clear on what that means, how can you tell if it was perpendicular or otherwise?
Well, all you have to do is inspect the hole. If the hole is going at an upward angle or a downward angle, that would not be perpendicular. Perpendicular would be if I took a pen and stuck it,
Okay.
if this is the wall, it would be like that.
Okay.
Level with the ground and perpendicular to the wall, means a 90-degree angle.
Okay. And that, when your visual inspection of that, that's what that indicated to you?
Yes.
Okay. And did you, in fact, did you yourself recover the bullet, or was that something that was done in your presence?
It was done in my presence. It was actually conducted by Officer Fitzhugh.
Okay.
Fitzhugh, Fitzhugh. H-U-G-H, yeah, Fitzhugh, yep.
Thank you. I have nothing further.
No questions, Your Honor.
I don't know.
Thanks, sir. Sorry.
Officer Mott.
First name is Patrick, D-E-T. R-S-E-K. Last name is Smart, M-A-T-T.
solemnly swear or affirm testimony about to give you the truth.
I do.
Officer Mott, what do you do for a living?
I'm a police officer with the city of Detroit, assigned to the homicide section as a homicide detective.
Okay. How long you been with the city of Detroit?
14 years.
How long you been with homicide?
1 year.
Right. Sir, are you what's known as the officer in charge of this case?
Yes.
All right. Do you know these defendants?
Yes.
All right. Can you tell us, have you, prior to today, you've seen them all, is that right?
Patricia Richardson and Mr. Richardson.
Okay. You never saw Mr. Witcher before?
No.
Okay. Did you have an opportunity to take a statement from somebody?
Yes.
Who?
Patricia Ann Richardson.
Did you see her?
Yes. She's sitting at the defense table in a burgundy top, black pants, black boots.
Before taking her statement, did you advise her of anything?
Yes.
What?
I advised her of her constitutional rights. Detroit Police Department has a constitutional right form. I had her to read the rights out loud, and she affixed her initials next to each statement that she read and understood.
All right. And was that statement actually recorded as well?
Yes.
I'm going to show you. This is going to be number 7, Your Honor, because I can't find my. Do you have the exhibit?
Oh, I had to use my
Oh,
copy. It's
okay.
mine.
All right.
I'm marked
I
yours.
have it.
Oh, you have it?
Yeah. I'm gonna, let me see. This is gonna be People's Exhibit number 2. Did you advise her on Detroit Police Constitutional Rights Form?
I did.
All right. Did she tell you that she could read and write
Yes.
prior to taking a statement from her? Did she tell you that she wanted to give you a statement?
No.
I'll use the vote here, Your Honor.
Any questions?
Not at this time.
Sir, what did she tell you, if you recall, with regard to, did you ask her about a gun that was in the house?
Yes.
What did she tell you with regard to that gun, about that gun?
Ms. Richardson stated that
Your Honor, I'm assuming that this is coming in.
Taking it
Only as to Ms. Richardson.
strictly as it relates to her.
Thank you.
Thank you.
Mrs. Richardson stated that the firearm came into the house around about December 2nd of 2013.
Okay? And did she tell you where in the house this weapon was kept?
It was stored in her room that she shared with her boyfriend,
And who was her boyfriend, did she tell you?
Mr. Richards.
Mr. Witcher?
Richard
Which one?
Harvey, I believe is his first name.
Okay.
Judge, if I might, these statements that the officer has alleged were made by Ms. Johnson, I'd ask if there is any written recording of these statements.
Is there a written recording of the statements?
Yeah, the statement was memorialized by a DVR recording.
Okay.
So the
Yeah.
answer is there's a DVR, but not a written, written statement.
Correct.
It's just a DVR
All
statement.
right, I just wanted to verify.
So it's an oral statement that was recorded by DVR.
And has it been downloaded?
Yes.
And, Your Honor, for the record, It has been provided to counsel as well.
Okay.
She told you, what did she tell me she told you about the weapon?
That she brought the weapon in the house around about December 2nd, 2013. It was given to her. I need to refresh my recollection with some information that I presented to her.
All right. Did you have her, like, identify some pictures and sign them?
Yes.
All right. Did she sign, was there some question and answers on each one of the photographs that you had, and you had her sign them?
Yes.
All right, I'm going to show you, again, People's Proposed Exhibit number 2, and ask you if you're familiar with all 3 of those pages.
I think it's 4 altogether, but
All right, well, one of them's a constitutional rights form, is that
correct.
right?
Yes.
All right, so what picture was the first one you showed?
The first photo that I presented to Ms. Richardson was a photo of Robert Richardson.
Okay, and did you ask her some questions?
Yes, I asked 3 questions as in reference to the photo.
What'd you ask her?
The first question, do you know this person? Ms. Richardson's answer was, that's Robert. Question 2, how do you know Robert? The answer is, I am married to him. Question, is this the person you left the kids with while there was a gun in the house? And her answer was yes.
Okay, what's the next one?
The next photo that I presented to Mrs. Richardson was a photo of a Tyrell Harris. And I asked her some questions as it relates to that photo that I presented to her. First question, do you know this person? Question, her answers to that question was Tyrell. Question, where do you know this person from? Her answer was my daughter's kid's father. And question 3, is this the person that you received the gun from? And the answer is actually cut off from this document that I have here, this copy document that I have here.
Okay, and what was the answer?
Yes.
All right, and then what's the other one?
The last photo that I presented to Mrs. Richardson was Harvey Richards. And the questions that I asked in relationship to that photo that I presented to her was question 1, do you know this person?
Did you say Harvey Richards?
Richards.
And I think it's clear that I'm not admitting these with regard to anybody else other than Miss Richardson or Miss Johnson, or Miss Johnson Richardson. Go ahead.
Okay. The questions that I asked as related to the photo was question 1, do you know this person? Her answer, that's Harvey. Question, where do you know Harvey from? Her answer, he's my kid's father. Question, is Harvey the person you went with to pick up the gun from Tyrell? And her answer was yes. She signed this photo along with the date and the time.
All right, now did she tell you about what her responsibility, or what she was responsibility was with regard to any children that were in the house that day?
She was babysitting her grandchildren.
All right, and did she tell you if she knew where that gun was? Did she tell you if she left her grandchildren in the care of someone else?
Yes.
What'd she tell you with regard to that?
She left the children with her husband while her and her boyfriend ran errands.
Okay, so she left him with her husband, who was, just so we can,
Robert Richardson.
okay, while her and her boyfriend, who was,
Harvey Richard.
okay, went to run errands. Is that what she told you?
Yes.
And did she tell you where this gun was when she left them?
It was left in the bedroom that her and her boyfriend shared in common.
And did she tell you if she knew whether this gun was loaded?
Yes.
What did she tell you about that?
She stated that the gun was loaded.
All right, and did she tell you if there was a safety of any kind on it?
I don't recall asking that question or her making any admissions to a safety being on the rifle.
Did she tell you anything with regard to the television situation in the home?
Yes.
What did she tell you with regard to that?
There was a television that was in a room that she shared in common with her boyfriend.
Okay, and what about any other working televisions?
I don't recall if she stated anything about any other working televisions in
Did
the
she
house.
tell you how many kids she left with Mr. Richardson that day?
Yes,
How many?
3.
Did she tell you how long she had been gone from the residence before something caused her to go back there?
I don't recall her answer to that.
All right. Did she tell you if she returned to the residence?
Yes.
Did she tell you why?
Yes, she received a phone call from her husband, Mr. Richardson, about a shooting that occurred at the house on Tuxedo.
Did she tell you about what time she received that?
If I recall correctly, it was approximately 4:30 p.m.
Do you remember if she told you the names of the 3 children that were left there?
I believe she did mention the first name of the children that was there.
All right. And their ages or not?
I don't recall if she gave me the ages.
All right. Do you remember the first names that she told you?
Yes. She referred to the victim as J.R. or Junior. There was also another male there by the name of Jermaine. And the young lady, third grandchild, her name was Janiyah, I believe.
Okay. All right. Your Honor, I'm going to move to admission of People's Proposed Exhibit number 2, which would be the advice of rights and three question and answer pages with photographs.
I would say.
Thank you. And I have nothing further.
Thank you. Detective, is it Detective?
It's also mine. It's fine.
Okay, thank you. You had contact with Miss Johnson on the 16th of January.
That's correct, ma'am. Yes, ma'am.
And she was in custody,
She was.
and that's why you went through her rights with her. When somebody's in custody, you go through a process of informing them of their rights.
That's correct, ma'am.
Okay. And she answered your questions,
Yes.
and the purpose of that interview was to get certain information from her. Is that correct?
Yes, ma'am.
All right, and she provided that information to you.
She did.
All right. She told you that she lived, in fact, on Tuxedo
Yes.
with Mr. Witcher and Mr. Richardson.
Correct.
Okay. And she described Mr. Richardson as being her husband.
Yes.
Is that correct? Did you learn how long they had all been living together there?
Yes.
From Miss Johnson?
Yes.
She told you?
She did.
Okay. And would she tell you how long she'd been living there?
If I recall from the interview, it was approximately a month.
Okay. And she told you that she and Mr. Witcher moved into the home of Mr. Johnson.
Yes.
Mr. Johnson being somebody that she had been married to,
Correct.
and that, did she tell you?
Mr. Richardson.
Yeah.
I'm sorry.
Yeah,
Thank
Robert
you.
Richardson.
Thank you. Mr. Richardson being somebody that she had been married to, correct?
Yes.
And so, did she tell you how long they had been living apart, separated?
Well, based on the answer that I received, I took the answer to believe that she was still currently married.
Well, she was still currently married, but they had been separated and living apart for some period of time, number of years, isn't that?
I don't remember ascertaining that information from her.
Okay. All right. Well, you, you knew that Mr. Richardson was very ill. Is that correct? Did she tell you Mr. Richardson was very ill?
She did.
And did she tell you that the reason she and Mr. Witcher had moved into the home was to care for Mr. Richardson, who was very ill?
Yes.
And that was at Mr. Richardson's request and an arrangement that worked for everybody?
Yes, ma'am.
Okay. And, all right, so you learned from Ms. Johnson that she and Mr. Witcher had been living in this home for about a month.
Correct.
Ms. Johnson, you said, told you that she brought a gun to the home, correct? And she told you where she got the gun,
Yes.
when she had brought it to the home,
Yes.
and did she tell you where the gun was normally kept in the home?
In the bedroom that she shared with her boyfriend.
And, well, did she specifically tell you? Well, strike that. She specifically told you where in that bedroom the gun was kept, didn't she?
Yes,
She told you it was kept in the closet.
she did.
And you asked her, in fact, didn't you, how'd the gun get out of the closet?
Correct.
And she said, I don't know how it got out of the closet.
That was her response.
Okay. Did she also tell you that the children were not permitted in that bedroom?
I don't recall that from the interrogation, but
Well, she did tell you that the children didn't play in the bedroom. They didn't go in the bedroom. She told you that, didn't she?
I don't remember.
In the living room, you indicated that well, strike that, because I don't know if you said this or not. In the living room of the home, is there in fact a big TV?
I didn't actually make the scene. My partners, Sergeant Bowser and Sergeant McGinnis, actually was the preliminary investigators on the scene.
Okay, so you don't know exactly how that home was set up?
Correct.
Where, in fact, the children's playroom was, or where, in fact, the children were allowed to go or not go within the confines of the home?
That's correct.
And, all right, you asked her when she left the home who was at the home, correct?
Yes,
And she told you who was at the home.
she did.
The children were there.
Correct.
The children that she babysat.
Correct.
The children she regularly babysat for.
That's correct.
Her grandchildren.
Her grandchildren.
And she told you who she had left the children in the care of.
Correct.
All right. And did she tell you when she left the home where the children and the person she had left them in the company of, where they were?
I don't recall asking or remember what she said as it relates to
You
where they
don't
were at.
recall her telling you that they were not in the bedroom?
I don't.
Okay. And did she tell you that the reason that she had left the home, strike that, did she tell you who she had left the home with?
Yes.
And who did she tell you she left the home with?
Her boyfriend, Harvey Richards.
Okay. Did she tell you what errand she was running?
I don't recall if she stated what specific errand that she
Did
ran.
she
At.
tell you what time she left the home?
Yes.
What did she tell you about the time she left the home?
I think it was an hour before the incident,
And what time was the incident?
approximately 4:30.
And so do you recall then why she told you she had to leave the house at that time?
No.
All right. You don't recall her telling you about having to take another?
Objection, this is hearsay.
Well, I'm asking him if he recalls.
Yes. Go ahead.
Do you recall her telling you that the reason she left was to take another daughter to an appointment that needed to be accomplished before the end of the business day?
I don't recall.
Okay, that's fine. I have nothing further, thank you.
Any questions?
No, Your Honor, nothing further. Oh, I'm sorry.
No, they don't.
Okay. All right.
Thank you, officer.
You're welcome.
Oh, did you have something additional to this witness?
No.
Oh, okay.
I either am going to recall Ms. Tubbs just for the brief testimony about who uses oxygen in that home, or council can stipulate Mr. Witcher's on oxygen.
You know, she's already called the witness, for the record, I'm objecting, I'm not gonna stipulate that, is it?
Okay,
She's
we
already
can,
called the witness.
yeah, let's put this tough safe out.
Okay.
Okay, that's fine. Yeah, just for 1 second. Okay, Ms. Tubbs, you're still under oath, okay?
Okay.
All right. You identified Mr. Witcher, is that right?
Mhm.
As a person sitting at that table.
Yes.
Do you see him?
Yes.
Okay. Do you know if do you know anything about oxygen? What, with regard to Mr. Witcher?
You said what now?
Back to the thing, I'm gonna object to the form of the question, we have a total lack of foundation here. I don't know what
It
that
doesn't,
question
it's
even
pretty,
means.
it's pretty broad in terms
That's right.
of the knowledge of oxygen.
Okay. With, ma'am, you indicated that Mr. Witcher is your child's grandfather, correct?
Yes.
All right. And how long had you known Mr. Witcher?
Years.
All right. Do you know if he used anything to help him breathe?
Yes.
What?
He's on oxygen.
Okay. And do you know are you aware if there is or if there is anything in the home to assist his breathing?
Yes, oxygen tanks.
Okay. Do you know where the oxygen tanks were kept?
No, I do not.
All right.
Well, it's tough to keep it
Okay.
unless it's in
She
some
said
form
no,
container,
so
but-
no objection.
Okay. Have you ever seen oxygen tanks at that home?
Yes.
All right. Where did you see them?
Living room, dining room, maybe everywhere. But I don't know where they're kept.
All right. You don't know where they were kept?
No.
Right, where they were stored. All right. I have nothing further this witness. That's it.
No question. Yeah. Okay, thanks very much, ma'am.
But I found my number 2, so now
Oh,
I don't
okay,
need a
so
7.
Got it. So 1 through 6 were received,
Yeah.
and you have nothing additional at this time.
No, I do not.
Moving over on all counts.
Right. You want me to argue first, or do you want, how, do you want,
Well, let me tell you
all right?
what I have been able to work,
Okay,
and then we'll just hear from folks.
okay.
And there's certain fundamentals that are not at issue. We know that the child at age 4 died as a result of a gunshot in the left chest, slightly upward trajectory, left to right. There was an exit round that was retrieved from the door chamber wall. In that bedroom, it appeared it was occupied. There were only 2 bedrooms, and it was not the bedroom occupied by Mr. Richards. We have an excited utterance, which I'm at peace with, was indeed an excited utterance, by the 4-year-old that indicated that she was, the little girl discharged. So we know that there's we know the cause, the death, we know the cause of the death. We do not know whether it was close range fire, nor is that particularly relevant to the situation we have here. We know that there were 3 folks who lived in that home. And we know how the children got into the home that day. So, We know that there was a weapon. Ms. Johnson acknowledges by her statement that she brought the weapon into the home some month before. It is not a garden variety weapon. It's a long gun. It describes an AK-47 with banana clips taped together. It is, the only reason I say that is it is not something that could be easily concealed. It is a visible weapon. We know that the youngster, the deceased, was there from the night before. We know from the child's mother that Patricia had the youngster drop mom off. I think reasonable inference would be that Grandma, Ms. Richardson, brought the child back to the home, Ms. Johnson, where the child was found. It would strike me that what your theory is, it's obviously an act of gross negligence on the part of all three, of each of these individuals. And I'm taking from this that your theory of gross negligence, and I'm not trying to put words in your mouth, deals with, and I looked at the standard jury instructions just to give me a quick fingertip reference here. And it goes back to People versus Ord, which I sort of remember, which is the three-pronged test. And then there's a case called People versus McCoy, which is quite simple and useful, I think, for our purposes. That's the whole business of speeding. And we can all understand the idea of going 100 miles an hour in a neighborhood or something. That'd be easy in terms of establishing gross negligence. Driving a car in and of itself would not be, but the manner in which one drives it. And then the case law, and McCoy particularly points out that 100 miles an hour, you could extrapolate from that the act of gross negligence in failing to perform a duty or leaving. But it also can be that you can be driving at a very normal rate of speed if you've had foggy conditions or something of that nature. Okay, so that's the legal framework. So what your theory will have to be, I think, is that the two individuals that stayed in that room with the weapon not hidden between the bed and the wall, loaded in a fashion that would be able to be used by a child, and then allowing that weapon to be accessible to the children, was an act of gross negligence. And that the babysitter that day was grossly negligent by his own admission that having observed the weapon, knowing the weapon was accessible to the children, and knowing they were right there in the room, in the space. And I think he said, but you can correct me on this, that he was sitting on the edge of the bed when the weapon was actually discharged.
That was a statement.
So he knew the children were playing about the area when the weapon was fired. But that would be his gross negligence in his failure to act and allowing those conditions to exist. Now, I believe that that's where we are, and that's where I'm not trying, as I say, I don't need to put words in your mouth. That's where the conclusions I'm drawing. If there's more you want to bring to my attention, Ms. Goldfarb, I'd be happy to hear it, but I also want to hear from counsel.
Well, Your Honor, also that this weapon was not secured in any way. It wasn't made safe. These were 4-year-old children. So, I mean, there's no evidence that they climbed anywhere to get it. They were in the house with a rather large weapon. And it is clear, Your Honor, that it was from the physical evidence that it was the 4-year-old because it required that somebody be beneath the child to shoot him in his chest. The entry room the entry 19 inches from the floor indicates that this was somebody who was short, who was low to the ground. The weapon was low to the ground, not in a closet, not anywhere. It was on the ground and unsecured, and with no safety. Miss Johnson admits she brought it into the house, admits she left children there, knowing the children were playing around in the home. And this is a small house with a 2-bedroom house. They're
There's another presumption that I think we could make that I don't think is a stretch of some sort, and that is that the weapon was not stored in some sort of a safe place, up on a shelf or something of that nature. There's nothing to suggest that whatsoever, and that somehow that it suddenly ended up on the floor while they were watching television.
Right.
There's nothing there. So the
there's
logic is that it was there when Miss Johnson and Mr. Richard departed that day.
Yeah. There is no evidence that it was stored, or that any child like was searching for it or climbed on anything. There's no evidence there's anything there to climb on. This weapon was low to the ground, completely accessible to two 4-year-olds who were playing in a house having been left there by 3 people who were in charge of the children at the time, and without securing it, without making it safe, with magazines in it, fully loaded, all amounts to gross negligence on the part of all 3 of them, and that is the theory, Your Honor. And of course, with regard to Mr. Richardson, he's also charged with careless discharge, which does not require that he actually be the one who discharged it, but that the weapon was under his immediate control at the time that it was discharged. In regard to Mr. Richardson.
Do you have to charge, is that
Right.
charged in the alternative?
No,
You don't feel you
no,
have to?
no, I don't. And
And the felony firearm is a bit of a reach?
not with regard to felony firearm would be that they were felons in possession, all 3 of them?
That's easy.
All right, and
How
that
about
felony
felony
firearm is attached to either the felon in possession, the manslaughter, or the felony firearm attaches even to the felon in possession. So you can be a felon in possession and guilty of felony firearm, and they were all 3 in possession of the weapon. They it was in the room where Mr. Richard and
Actual or constructive possession.
Actual,
at some given
right.
point during the
Right.
course of that act.
right, yes.
Just wondering.
Thank you. Judge, I totally understand the, why the prosecutor's office thinks they need to bring this charge. I mean, it's a horrible situation that happened. We have a young child that was killed, and why the prosecutor's office thinks they need to bring this charge. I mean, it's a horrible situation that happened. We have a young child that was killed, and a grieving family. And so I understand their inclination, their desire to bring this kind of charge. The problem I have with this is I think that the case law is pretty clear. If you're going to charge a manslaughter under a theory of gross negligence, it requires something more than ordinary negligence. It requires gross negligence. And all the case law I have seen and the cases I have read about this talk about there must be some level of foreseeability. The cases I've seen that talk about the, there was a situation, a case, People versus Stanko, which was a Court of Appeals case, 2012, that dealt with a similar type charge where a parent was charged because of a child who died, and the parent was accused of gross negligence. The child in that situation, I think, actually fell into a pool and drowned while the mother left the child unattended and went into the house. And the Court of Appeals spent a considerable amount of time in that case talking about why that was certainly a dangerous situation, but why in that circumstance there wasn't any foreseeability. That it took, was a little bit more of, well, okay, they could have known, should have known. the court even went a little bit further to talk about, in a situation like that, you have to have a little bit more. And what the court talked about, refusal to take precautionary steps to prevent the injury, knowing of, in that case, the child's proclivities. And the other case I found dealing with similar issues, again, the court talked about this, had the same kind of language, that there must be something more, refusing to take action when you know something. In this case, what we have, as to Ms. Johnson, that we know that she is a loving, caring grandmother, that her children regularly entrust her to take care of those children. She regularly sits. She picks them up. She drops them off. She keeps them. Not just one child's children, but another child's children. By all accounts, a loving, caring, devoted grandmother. Even moves into her ex-husband's home to help care for him when he falls ill. I mean, this is not a woman who is, any evidence on this record that she is, not a caring soul to members of her family. What we have is, according to the testimony, evidence that she made a statement saying, yes, I brought a gun into the home. It is kept in a location that the children normally do not have access to. Her bedroom, in her closet. And there is nothing on this record as to Ms. Johnson that it's anything other than that. There is a co-defendant's statement, which is not applicable and can't be used against Ms. Johnson. And in that statement, what he says is, after she's gone, I make a sandwich and go into her room to watch TV. I mean, there is nothing on this record from which we know, or we can assume or presume, that she knows that those children are being given access to some place that I think the officer indicated in her statement. She says it's kept in the closet in the bedroom. How did it get on the floor? She doesn't know. We know that sometime after she leaves the house and leaves those children in someone else's care, the unthinkable happens. They are given access.
Finish that off. Even if I left a loaded AK-47 in a bedroom closet, could that constitute the three little ones, the oldest being 7? Can that rise to being grossly negligent?
When I look
Given the size of that home condition?
Well, Judge, when I look at those cases that deal with situations like this where family has been charged under a gross negligence theory for leaving basically an unsafe environment for children, what the courts have said in the both the Staffeld case and I believe the other case that I have with me is Albers. In both of those cases, the courts talk about something beyond ordinary negligence.
Oh, yeah.
Something beyond that, talking about, knowing and not taking preventative measures. What kind of preventative measures? Ms. Johnson, in her statement, says, yes, there's a gun in the house. It's in a closet, in a room where the children, don't normally have access. Did she refuse to take preventative measures, knowing, as the court said in Stafford, the proclivities? She had, because those children don't have access to that room, to that closet, if it's something, if on this record there was proof that these children were everywhere all the time, getting into everything, climbing, searching, Maybe. And then if she didn't do anything. There's nothing on this record. In fact, the child's mother who testified said, I've never been in those bedrooms. I don't know what's in those bedrooms. When my child sleeps there, my child sleeps on the couch. If there was some indication that those rooms where all of this medicine and oxygen tanks are was someplace the children regularly played, maybe. And then if under those circumstances she refused to take preventative measures, maybe. But none of that on this record. All we have on this record is this loving, caring grandmother knows there is a gun in the house. And on this record, the only thing that we can attribute to her is that she knew it was in a closet in a bedroom. I don't see on this record where there is sufficient evidence of her gross negligence, of her refusing to take preventative measures, knowing the proclivities. It's a tragic situation, and Miss Johnson suffers, no less than any of the parties. I mean, she is as devastated by this as anyone. And, but on this record, there is no proof of gross negligence on her part. Something I guess we can all agree, shouldn't have been done, but clearly on this record doesn't arise to the level of gross negligence.
One second, please. 1 second, please. Okay, Judge?
Yeah, just read it, it's to you.
Thank you very much, Your Honor. I do agree with Ms. Nanarino when I say that this, of course, is a very tragic, very, very tragic incident. My client, at least according to his statement, was in the room. And by being in the room with the children playing, thought he was watching. They were there. He did not, I assure you, and even by his statement, intentionally or even grossly try and put those children in danger. And I think from his statement, it wasn't as though he left them in the room. He was there with them. Now maybe he should have done things differently, but he was there with them, telling them to get on the bed, watch the TV, and then the unthinkable happened. I don't think what he did amounts to gross negligence. Gross negligence would have been putting them in a room there and just leaving and going someplace else in the house. He didn't do that. He was staying there with them, trying to get them to stay on the bed. It wasn't his room. It wasn't his rifle. He was just simply watching the children, keeping them on the bed to watch TV while Ms. Johnson and Mr. Richter went out to run some errands. I don't think, Your Honor, that amounts to gross negligence based on the cases that have already been cited by Ms. Nanarino.
Judge, I agree with both counsels that in the whole case, that the level of negligence here does not rise to gross negligence as to all three defendants. But I move to dismiss the entire case against Mr. Witcher, because Mr. Witcher is in a totally different circumstance here, because there really hasn't been any evidence introduced against him other than the fact that Ms. Tubbs says that she knows that he lives at the residence, and that's really it here. I asked her, did she specifically make an agreement with Mr. Witcher to watch her children? I answered that in cross-examination. She said no. So there's no agreement between the two of them. The fact is that Mr. Witcher is the child's grandfather. There's no legal guardianship here. He's not the child's parents. He has no duty to watch the children, because either a family relationship, grandfather doesn't have the duty, nor any agreement. Furthermore, we certainly all agree that the two statements of the co-defendants cannot be used against my client under Crawford versus Washington. There's no evidence here whatsoever And of course, that my client, first of all, was even in the house. That differs from one of the co-defendants. He wasn't even there. There's no evidence of that. There's no evidence that he even knows anything about the gun. He doesn't know. There's no evidence because, again, that came through the statements of one of the co-defendants. There's no testimony here that he knows about the gun, that he knew that it was in the bedroom, or that he even stays in that bedroom. There's absolutely no evidence against Mr. Witcher other than the fact that he stays in the house. And there's some evidence about prescription pills. Again, that's insufficient. There's no evidence that that's not evidence to show that he stays in the same bedroom, or again, that because there may be prescription medicine that he lived, that he stayed in the bedroom or he knew about the gun. There's absolutely no evidence, in my opinion, that the court could use here to bind him over on any of these charges. So I would move to dismiss it. Of course, with Mr. Witcher, it's count 1 is against it on manslaughter, involuntary manslaughter. Count 2, possession of firearm by the felon. No evidence here that he was in possession or knew that the gun was there, so he obviously couldn't be in possession. And of course, the felony firearm would fade away. So I would move to dismiss the entire case against Mr. Witcher.
Stay with the, go ahead, thank you. Stay with the Witcher question.
Okay.
What have you got that shows that he had, let's just, she brings the weapon into the home. And I want to be careful here when I try to think about how we got the first statement that got him going along to obtain the weapon. Let's skip that one for a moment. We've got the weapon in the home. What do you got on the day in question that would demonstrate that he would leave those children with access to that loaded weapon? Because that's what you really have to have, don't you?
Well, the evidence with regard to him is not other than the statement of the co-defendant and the statement of the mother that he shared a room with her.
Yeah, I get that.
And have his, the items that are unique to him, like his medicine and his oxygen in that room. We have a huge, we have a big weapon. I mean, not something that's that you could put under a bed, because you can't put anything under the bed. Not something that you can, that isn't, if it's put in a closet, you can't see in plain view. We have a big weapon, Your Honor, and I would suggest that that we have his knowledge based on what the mother said, that children come there all the time. He's there, that children are always babysat there. So it doesn't, I would suggest to the court that it doesn't require that he know that moment or that day, but that as a rule, that he knows that children stay there regularly, that they play there. The proclivities of 4-year-olds to play is like obvious. That when you have a big thing with, they're going to play with it. That it is grossly negligent that he had in his room, and you can infer knowledge just based on the size of the weapon, and that he stayed there, and that he knew that children are always playing in that house. You can't, and to say that, well, there's nothing, that there was any lock on the door, lock on this weapon, lock on the closet, nothing to indicate that this was in any way secured to prevent those children who were regularly playing in the house from access to this huge weapon. I would indicate that would be gross negligence for Mr. Witcher and for all of the other defendants as well.
Unless I'm missing something, there's no evidence this was his room. That only.
I'm sorry, there is evidence.
Other than the co-defendant's statement.
Well, sure, there's plenty of evidence that there was oxygen tanks in that room. And there were no oxygen tanks in the other bed.
I believe this Tubbs testimony is, I don't know where the oxygen tanks were kept.
Right.
No, but the officer that responded to the scene
Sergeant
testified
Bowser.
on the tanks.
Yeah, but that doesn't prove it's true.
No, but I mean, these are reasonable inferences at a preliminary examination.
And Ms. Tubbs testified the first time she testified that she was aware that Mr. Witcher and Ms.
That he was the user of oxygen.
And that he shared a room with Ms. Johnson.
Yes.
She testified to that as well. That she just didn't know which one was
I
assigned
don't
to
think
which
there's any
person.
problem, to put it simply, I don't think there's any problem with Mr. Richards, quite frankly, sitting on the edge of the bed, there's a weapon right there, and it's a loaded AK-47, and you let the 4-year-olds and 7-year-olds play. that's gross negligence. That's not a difficult case for me. I think as it relates to Ms. Johnson, I don't think that's a particularly difficult case. You're bringing a weapon into the home, and then you're asked to be the babysitter of these children, and you are by definition, regardless of where, quite frankly, where that weapon was kept, when you keep a loaded AK-47 in the home, you are creating by immediately a grossly negligent situation where they would have apparently access to that weapon. In this case, we have had ready access or easy access. There's nothing to suggest that they had to get the weapon from some other location and bring it into the bedroom that day, the children that is. So I think that that's relatively straightforward in terms of proofs as to Ms. Richardson. I think it's a much closer question as it relates to Mr. Witcher. In terms of what proofs or evidence has been presented here today. And it's always a challenge when you've got multiple statements and so forth. We know only that the weapon is in the home. I don't know that there's much to demonstrate Mr. Witcher's knowledge prior to that day of the weapon in the home. I have to admit that. We know that there is a weapon by the side of a bed that does not have where the weapon could not be hidden, but I do not have any evidence to demonstrate that Mr. Witcher that there was, the question would be, is there anything for purposes of a preliminary exam that would suggest that the weapon was elsewhere and then brought to that exact location where the children could play that afternoon, which is sort of a negative, which is a negative. Or may I reasonably infer that the weapon was there and therefore accessible to the kids in the absence of anything to the contrary? And I think that's probably the more reasonable inference that a court can draw. And if I can draw that reasonable inference, that the weapon was there, absent anything else, then it would be, since it is his bedroom, shared in a joint bedroom, I think you can reasonably find that he was aware that the weapon was accessible for the kids also. I think it's a very close question as to him. But that said, I think under People v. McCoy, it is a question that is ordinarily for the jury, and I think it would be in this case ordinarily a question for a jury. The parties, all three, I believe the evidence is demonstrated sufficient to show probable cause both as to the crimes charged and a probable cause as to all three having committed the crimes. They will be bound over on all counts as charged. Unless there's a reason, the bonds will be continued. Is there any reason not to continue the bonds?
Your Honor, I would ask for a referral.
I'll do a referral.
Thank you.
Judge, I would address the bond Mr. Witcher versus the court can see it on Oshie.
What's your bond now? It's a $200,000 cash or surety?
The court's heard the evidence of what evidence there is against Mr. Witcher here. Quite frankly, I understand and I respect the court's ruling, but I think that, at least in my opinion,
Well, let me be perfectly,
it would be a difficult case.
let me be blunt. He has an extensive record going, but it's an old record. Ms. Goldfarb, whatever they call it, pretrial services, the present bond was $200,000 cash or surety, and the recommendation is that it's excessive, it's not a capital offense. Now, none of us are, in no one, in common decency, is suggesting it's not a grave offense. But we're talking, it's a matter as lawyers. They are recommending a $50,000, 10%. Do the people have any objection to that reduction?
No, I'm going to leave it to the court's discretion.
All
Just for
right.
the record, I move for the reversal of the bond.
Well, I will leave it at that. I will reduce it to $50,000, 10%, based on the recommendation from the forum.
Your Honor, is there a referral there for Mr. Richardson?
I will make a referral for Mr. Richardson because at least one and possibly two of the individuals are in jail, may not be able to come out, whether they have the ability to make bond. We will set the agreement on the information for February 21. And I will make that referral as it relates to Mr. Richardson.
Thank you very much, Your Honor.
Thank you. $50,000, 10% as to Mr. Richardson.
Thank you, Judge.
Thank you.
Thank you very much, Your Honor.
Thank you very much.
Fourteen dash,
Stafford,
554997.
like
Tentative agreement.
Albert.
Are my
Stafford.
are my exhibits up now? Did I give them the report yet? Or I did not give them?
Floyd. Crawford and
Washington Crawford.
Can you sign this reduction?
Was it Washington and Crawford?
You said Washington versus.
He may have said that,
Mr. Harris, Crawford versus Washington.
I'm waiting on her to take this picture.
The ones with the stickers.
Yeah, with the yellow stickers.
Where are they?
Those stickers there, I'm like, oh, our stickers, why?
No, the exhibits with the stickers.
Oh, right here, I put them right here, you gave them to me. They're right here. And I got my phone, that piece of paper.
Fifty-ten, correct?